Good morning, ladies and gentlemen. Good morning, members of the media. Good morning, all citizens. My name is Dinesh Rambali. I am the Member of Parliament for Shogunas West. With me this morning is the Honorable Ms. Jayanti Lakshmidyal, Senator, sitting in the opposition benches. Ms. Jayanti Lakshmidyal, thank you so very much. It is, of course, a pleasure to have you on, and my pleasure to be with you too in this our opposition press conference. Ladies and gentlemen, on behalf of the Honorable Leader of the Opposition, Mrs. Kamala Prasad-Bissessar, it is our pleasure to invite you to treat with certain critical matters. Our nation is at a particular critical juncture right now, and so we are doing and performing our role as public officials, ensuring accountability and transparency on the part of the government. As a government in waiting, we of course continue to deliver on our mandate being a government in waiting. I would like to start off by saying that on behalf of Mrs. Kamala Prasad-Bissessar and all our parliamentarian colleagues, that we are grateful to the members of the media and to all citizens for the support in terms of when we have to marshal our points, our arguments, where we want to hold the government accountable. It is the support of the people that gives us the justification, which validates what we do. It is the support of the people which puts us where we are in the parliament and even outside on public platforms such as this press conference, where we can say what we want to with respect to holding the government accountable. Today is, of course, the anniversary as well. 24th of May 2010 was a very significant milestone in the history of Trinidad and Tobago when our political leader, now leader of the opposition, Mrs. Kamala Prasad-Bissessar, would have led a partnership government commencing the 24th of May 2010. And today, 24th of May 2023, we stand poised to ensure that we, as a government in waiting, we are ready to take back government and to bring back good governance to the people of Trinidad and Tobago. Ladies and gentlemen, as I get into today's discussion, as agreed and discussed between Senator Lakshmidyal and myself, I will of course do a little introduction setting the context of something very important, namely the recent Privy Council ruling of Ravi Balgobin Maraj versus the Cabinet of Trinidad and Tobago, which really factors what is taking place at the local government arena. So I will set the context and of course we want to point out where, as a government in waiting, opposition, we want to go with this argument, and I will hand over thereafter to Senator Lakshmidyal. Senator Lakshmidyal, to most of you, I mean, people would know of her tenacity in the Senate, but of course I will hand over to her today because of her legal acumen. She is, of course, the person, one of the persons being led by Mr. Anand Ramlogan, Senior Counsel, that team of attorneys that did advocate this matter of Ravi Balgobin Maraj versus the Cabinet of Trinidad and Tobago and succeeded all the way up to the Privy Council. So I would give way to her. She, of course, being part of that legal team, will, somehow treat with the nuances and the niceties of the judgment. Something that obviously it seems as though it is beyond the comprehension of this PNM government, and particularly Prime Minister Rowley. So I want to start today by saying that this judgment of Ravi Balgobin Maraj versus the Cabinet of Trinidad and Tobago and the Minister of Local Government is a judgment given on the 18th of May 2023. And I point out that at the very inception to say that this judgment having been delivered last week, Thursday, we are 1 week later, and these are the headlines that we are seeing today. And I start with the Daily Express. All eyes on Rowley. Is Prime Minister going to call election date today? So we have had a ruling from the highest court of the land, set up and established by our Constitution. So it is our constitutional right to go to the Privy Council, to have matters determined, to have it adjudicated. The Privy Council pronounces on matters of fact and law so that it guides us. We have now had the ruling of the Privy Council since last Thursday, but today, which is 1 week later, we are now seeing all eyes on Rowley. He is the Prime Minister of Trinidad and Tobago. Well, he's supposed to be the Prime Minister of Trinidad and Tobago, purporting to act as Prime Minister, and 1 week later we are seeing headlines like this. AG, the Attorney General, all questions arising from Privy Council judgment to be addressed in Parliament. 1 week later, you know, we had this judgment last week, Thursday, and 1 week later we are now seeing this headline. No disrespect to the media that is reporting this. I'm saying it in the context of look at the scant respect or the total disrespect that this government is treating the population. Law Association, government must call local election as soon as possible. So that is one headline from the Express. And when we look at the other headlines, it does paint a dim view of the government. Look at it. Prime Minister breaks silence. Rowley to speak in House on Privy Council ruling. So we have to wait 1 week to hear what Rowley is coming to say in the House today, if at all he's saying something. But I think in the Senate yesterday, the Attorney General, A.G. Amor, would have said that, you know, some of these matters will be addressed by him. Another article, of course, is Law Association urges government after Privy Council ruling, call local election now. So this is something that we will be discussing this morning. Opposition leader threatens legal action. But for the leadership of Mrs. Kamla Persad-Bissessar, but for her holding the government to account, but for her high standards which she expects of officials in government, herself leading a government, as I indicated before, in 2010 to 2015. This is where she's insisting on good governance for the people of Trinidad and Tobago. And so that is where we will discuss some of those matters. I see Senator Lakshmidiyal, one of your colleagues in your upper house, made some comments about being embarrassed. I will leave that to Senator Lakshmidiyal to treat with. And of course, to end off with the Express. This is the editorial in today's Express. And of course it reads, ring election bell now. 1 week later, where you have had a situation arising where the term of office for local government officials has come to an end effectively March of this year, right? They moved to the Parliament last year. We will get into those facts in November 2022. That has now been deemed to be impugned or vague legislation on the part of the government. Hence the reason why the Privy Council ruled the way they did. And here it is now. We are in a situation where the term of office of that local government tenure would have come to an end in March 2023. We are now approaching June, and here it is, you see in ring election bell now. This is something that we have been saying all along, so we will be getting into those matters as we move along. Again, I want to look at the Newsday very quickly, just to give you all, why is it that we have this synchronicity of headlines, of articles, all saying the same thing? So one of the articles here, Law Association press public commentary, not contempt. We had none other than the Attorney General, the man who is enamored to ensure the welfare of the rights of citizens. And here it is that he is the one who came out last week, Thursday, immediately following delivery of the judgment of the Privy Council, and essentially threatening media and by extension citizens that they should be careful, trying to muzzle commentary on the judgment, saying that they can be held in contempt. Law Association has now come out, and again, this is yet another article saying that the press public commentary is not contempt A.G. Amor. I don't know what to say about A.G. Amor again. This is another article. This is Amor saying Prime Minister to speak on local government today. Again, another article. Senator is something that my colleague, it is front pages I'm dealing with. All eyes on Prime Minister Rowley to break silence. Why on earth, 1 week after Senator Lakshmidiyal is saying here alongside me, you're breaking silence? The Prime Minister getting a ruling like this is breaking silence a week after the event? I mean, such an important determination of our highest court of the land. So, option to call local elections or extend the term. That is something we're going to treat with in our presser today. And so, Guardian, we have the Law Association again. Government must call local election soon. Eyes on Prime Minister as he breaks silence. I can't imagine breaking silence, right, against the context we are living in now. Then you have government can legislate an extension of term expert. That is Professor Hamid Ghani, something we will treat with today. I beg to differ in terms of how certain things have to be done. And we will treat with some of the other matters. There's just one article. And again, this is something I would ask Ms. Lachmidial when she is doing her presentation. This headline, however, is a little bit misleading in my view, but Senator, you will treat with this parliamentarians to blame. No, parliamentarians to blame on this matter. So she will treat with that. So, ladies and gentlemen, I want to begin today by reading a quote that partly inspired me to take up law as my profession. And it says, wherever law ends, tyranny begins. I will repeat that. Wherever law ends, tyranny begins. And that is, of course, a quotation from John Locke, The Two Treatises of Government, 1689. This very simple and elegant phrase contains a powerful and important idea that democracies must enshrine the rights and freedoms of citizens by rule of law. And it is the rule of law that serves as the guardrails of rights and freedoms. The feature that separates, ladies and gentlemen, dictatorships from free societies is the rule of law. And the rule of law applies to everyone, from lawyers to members of parliament, and yes, even prime ministers. Under our constitution, the government of Trinidad and Tobago is a government of laws and not of persons. Political power must be obedient to the rule of law and not to the arbitrary whims and fancies of those in power. Ladies and gentlemen, last Thursday we had the benefit of the Privy Council ruling, the highest court of the land established under our constitution. That ruling, of course, as I recited for the record, in the matter of Ravi Balgobin Maharaj versus the Cabinet of the Republic of Trinidad and Tobago and the Minister of Local Government. As we all know, the Privy Council ruled in favor of Mr. Balgobin. And to make a long story short, the Privy Council found that the government's postponement of the local government elections, the date was flawed. You don't need to be a law lord to see what must now be done. Since last Thursday, the onus was on the Prime Minister to call the date for the local government election so that this matter could be rectified. The Prime Minister has instead deemed his golf game to be more important than the Privy Council ruling, and indeed the people of Trinidad and Tobago, including the thousands of local government officials. Ladies and gentlemen, this PNM government is sending a clear signal to the world. They believe that they are above the rule of law. I want to share another quote I am fond of, this time by V.S. Naipaul, and he said, "A government that breaks its own laws can also easily break you." And that is from A Bend in the River, words of V.S. Naipaul. That is precisely what the PNM want to do. They want to break the people of Trinidad and Tobago. They want to break our freedoms and our rights. There is actually an instrument to measure how close or far we are away from this ideal. It is called the Global Rule of Law Index, something that we have been speaking to in the Parliament since 2021, and now we have the recent index 2022. What this does, ladies and gentlemen, it considers factors such as constraints on government powers, absence of corruption, open government, fundamental rights, order and security, regulatory enforcement, civil justice and criminal justice. Trinidad and Tobago fell in its rankings in the 2021 report to number 63 out of 139 countries. So this is an indicator of how, as a government, we adhere to the rule of law. And we fell in rankings in 2021. Excuse me. And in the 2022 report, we fell even further by 4 spots. So in 1 year time, 2021 to 2022, according to the World Rule of Law Index, we fell 4 spots. So a further 4 spots to number 67 out of 140. Would you like to hear, ladies and gentlemen, some of the countries which are ranked higher than us? At number 42 is Rwanda, where there was a bloody civil war only 2 decades ago. They are ahead of us in terms of adhering to the rule of law. Rwanda, number 42. We are at 67. At number 57 is Kosovo, where there was also a civil war 2 decades ago. They are also ahead of us in upholding the rule of law. You know which country is ranked dead last at number 140? Venezuela. That's where Keith Rowley is taking Trinidad and Tobago down the road to. So instead of Trinidad and Tobago climbing the ranks in terms of scoring better on the rule of law index, we are dropping in our ranking. And you can see the reason why just by looking at the contempt, the disrespect, and the flippant attitude of the Rowley-led government towards the ruling of the Privy Council that we received last week Thursday. You will recall that following the ruling, AG Amor addressed the country, providing no insights whatsoever as to how the government intended to abide by the Privy Council ruling. Rather, he sought to threaten persons and the population with contempt in law if they commented on the ruling in a manner displeasing to the government. Worse than that, ladies and gentlemen, imagine we have to wait, as I indicated before, an entire week before we are likely to hear from the Prime Minister. And I have dealt with the newspapers. Based on what is reported of proceedings in the Senate yesterday, AG Amor announced a political miracle. It was as though this was a political miracle he was announcing. AG Amor said that Prime Minister Rowley is expected to break his silence in today's sitting. We are sitting in the lower house today, this afternoon. In so doing, AG Amor, and this is what we have to be very, very careful of, he seemed to be setting the stage by indicating that there is no cause for concern. So you have a ruling saying that your postponement of the general elections was unlawful. You don't say anything about it. You leave local government in total abeyance. We don't know whether local government officials are coming or going in the common parlance. And here it is now, AG Amor is coming in the Senate, announcing this political miracle that Rowley is coming to break his silence. But part of his narrative yesterday in the Senate was that there is no cause for concern. I want to say, ladies and gentlemen, AG Amor's reasoning and advice is wrong yet again. Number one, we want to make our position very clear as an opposition and government in waiting. The government must bring legislation to validate the actions of local government officials after November 2022. And number two, and this is very important, we have been saying this from day one, call the local government elections forthwith. So we are not going to accept anything less, because you, the citizens, the people of Trinidad and Tobago, deserve much more. Attorney General Reginald Amor is quoted as saying, and I quote now, "There is a well-known doctrine known as the de facto officers doctrine of great vintage, going back to the 1730s, established by, among others, the case of Scadding and Laurent. And that decision establishes that there is validity in the actions of the officers who were duly elected and continue to be duly elected until the decision of the Privy Council. There is no cause for concern." So that was part of what he said in the Senate yesterday. Ladies and gentlemen, AG Amor's own statement made yesterday in the Senate shows that that ancient and venerable de facto doctrine which he is seeking recourse in will only probably apply until the decision of the Privy Council, which was last Thursday. In other words, the de facto doctrine means that you are occupying the position as an official. You may not have the authority at the point in time to conduct certain transactions, to fulfill certain functions, to perform certain duties. But because you are dealing with members of the public, third parties, you are deemed to be conducting your job validly by virtue of the fact that you are occupying the position, and at the point in time you may not have known that you did not have the authority to do what you did. So that is the de facto doctrine. But by his own statement made yesterday in the Senate, That doctrine which he wants to rely upon to say that nothing that local government officials did during this period when they didn't have the authority to do so, that it will be covered, they will be immune from any civil suit or otherwise. That doctrine he accepts by his own statement. It will only apply until the decision last week Thursday. Hence the reason why on earth did you wait a whole week? Because you were leaving local government officials, according to your own reasoning, in limbo for the past week, because you are saying that they would not be covered by the de facto doctrine. Ladies and gentlemen, in relation to the authority of the councillors and the aldermen and the legality of their actions, all color of authority ceased last Thursday following the Privy Council ruling. So these councillors and others would be acting without lawful authority, certainly following the PC ruling. And I say certainly because we have to take this thing in a certain analytical order. This alone validates the concerns of Mrs. Prasad Bisesa and other opposition parliamentarians regarding actions taken by local government officials during this past week. So nobody was gaslighting the situation when Senator Jayanti spoke on our traditional Monday night platform to these things. She was speaking from a context and basis grounded in sound reasoning of the law. For so long as these validatory laws are not brought before the parliament and or local government elections is not called, local government officials remain legally exposed. In any event, the application of the de facto doctrine, and this is something I want you all to understand, the de facto doctrine, I spoke about how it can avail itself to those who are acting and in their own mind they are acting within their own authority, but it turns out they didn't have it. What we must understand now is that this de facto doctrine is limited to validating acts which are taken under an invalid authority, but it does not validate the authority under which the acts took place. In other words, ladies and gentlemen, the doctrine does not cure or give effect to the impugned or bad legislation by which the government sought to extend the life of local government. And this is what we have to find out from Amo and Prime Minister Rowley. Is the government saying that it is happy to leave its badly drafted legislation on the law books? Are they happy with that? Because AG Amo is not saying anything. We must also ask, why would a government want to leave it open where entities can challenge actions on the part of local government officials? Why would you leave it like that? Could it be that this is another way that the government can brief their affiliated P&M attorneys at law and pay them big legal fees to represent them in litigation? It is a critical fact that members of the public had notice of the proceedings brought by Ravi Balgobin Maharaj since about November 2022. This is significant, as it can be argued that in these circumstances, the de facto doctrine will not by itself save all of the rights, obligations, and other effects which would have purportedly arisen under this government's impugned or badly drafted amendments to the Municipal Corporations Act, which they went to Parliament with last year, November 2022. Ladies and gentlemen, this is one thing, Mrs. Kamla Prasad Bisesa, when she was Prime Minister, ensured that every single election that needed to be called according to law was called on time. And there's a reason for that. So you don't expose yourself to acting in a manner which is contrary to the rule of law, contrary to the Constitution, contrary to what is demanded of good governance. The only appropriate solution for preserving the rights, obligations, and other effects which have arisen under the government's impugned legislative amendments and which may not be saved by the de facto or other doctrines is to declare that in order to uphold the rule of law, these rights, obligations, and other effects have and will continue to have the same force and effect they would have had if they had risen under valid enactments for the period November 2022 onwards. In other words, there must be legislation brought to the Parliament for the purpose of correcting the wrong that the government undertook. and for ensuring that we validate the actions of those local government officials since November 2022 coming up till now. Otherwise, ladies and gentlemen, we would be faced with a highly undesirable situation if the legal rights, obligations, and other effects which have been relied upon by local government officials and the citizens dealing with them were suddenly open to challenge. The rule of law dictates that local government arena must not be without a valid and effectual legal system for the period in question, the present and the future. We just simply cannot have bad law remaining on the books and people continue to remain exposed, corporations continue to remain, and officials remain exposed for a period of time for what could be challenged as being illegal acts or unlawful acts or unauthorized acts. So we say that there is cause for serious concern intimate to the parliament and by extension the country how it is they are going to cure that bad legislation they brought in the first place and to protect local government. We are not prepared to hear any other nonsense he's coming to spew, because that is all what he's coming to say would amount to hogwash. I want to say very quickly the Law Association's views. I want to commend time and again Senator Lakshmi, I'm sure you did the same in a most respectful manner alongside myself. I did the same. We have had cause to raise concern why we are not hearing the Law Association when the public was turning to them to just simply fulfill their statutory duty. I want to commend them on this occasion for the statement that they issued yesterday. You see, Law Association has raised its voice in condemning the Attorney General for threatening the media and by extension citizens from commenting on the Privy Council ruling. It also pointed out the patently obvious so that even Keith Rowley could understand that the logical and lawful thing for the government to do is to call local government elections, and they use the words as soon as possible and consider validating legislation to remedy any illegality that may have ensued as a result of the postponement of the local government elections. So even the Law Association has shown the government delight in this scenario. Ladies and gentlemen, it is either the government is disrespecting the rule of law, and if they are not prepared to accept that they are treating you and your fundamental rights with scant regard, then it means that they are suffering from paralysis analysis. It means that they don't know what to do. It means Dr. Rowley, as the head of the cabinet, and his Attorney General, that they are clueless. They don't know what to do in this situation. And it is a situation which they have authored. Members of the media, ladies and gentlemen, the rule of law requires that the government comply with the law at all times. According to some jurists, this is a principle that requires a fastidious and unswerving fidelity to the letter of the law, a commitment which must be enforced rigorously by the courts. Permit me to simplify that statement further. The rule of law means that the government must always follow the law. This includes following the rules set by the courts and enforcing them firmly. Here it is, we have the Privy Council, the highest court established under the Constitution, delivering a ruling, but the government is deliberately ignoring it. Last week, the AG said we, the people in this country, could be held in contempt of court for discussing this decision. I want to tell him today, Senator Lakshmi Dayal, and ladies and gentlemen, that the entire cabinet, and I want to tell him and the local government minister, that they are all in contempt of the people. We, the people, hold you in contempt for undermining our democracy, for undermining the rule of law, and for undermining our fundamental rights. And if Dr. Rowley does not come today to the parliament and deal with the matter today, it will require going back to the courts to get justice for the people of Trinidad and Tobago, something which Ms. Jayanti Lakshmi Dayal will speak about. This is something which the Honorable Leader of the Opposition, Mrs. Kamala Prasad-Bissessa, Senior Counsel, is already treating with. As we speak, I know that she's waiting. She's not prepared to treat lightly with your fundamental rights. And that is why if they don't come to Parliament today and do what is necessary, we will be dealing with it. Today, myself, my colleague next to me, the leader of the opposition, the entire legal profession, and indeed the entire population of Trinidad and Tobago are demanding that this PNM government follow the rule of law and call the date for the local government election now. And before I hand over to Ms. Lashmidial, I want to say something about defending the Privy Council. Ladies and gentlemen, the Privy Council is an institution that has existed for over 100 years. And I want to tell citizens that we should all thank God. We should all thank God for that fact that it existed for that length of time, and for the fact that the Privy Council is still our highest court of appeal. Throughout its history, the law lords of the Privy Council have decided cases using various adjudicative tools to resolve legal disputes. I saw one author in particular say something, and this is why I'm going down this road, so that you don't get fooled by certain editorials that you're seeing. You see, the Privy Council, they consider precedents. They employ analogical reasoning. They rely on legal principles. These legal principles include the rule of law and the respect for legislative supremacy, something which it did in Ravi Balgobin Maraj. The Privy Council has existed long before our independence, ladies and gentlemen, and before our independent nation state came into existence. But what we have been seeing is, given the growing frequency with which this government is being adjudged as acting contrary to law, the Privy Council has had to say time and again that you, the government of Trinidad and Tobago, led by Dr. Keith, before our independence, ladies and gentlemen, high level of grit in being part of the legal team that fought this matter in particular, Ravi Balgobin Maraj versus the AG. So, Ms. Lashmidial, my apologies if I took a little bit too long, but you have the floor and you can take your time in treating with this judgment.
Thank you very much, MP Rambali. Good morning, ladies and gentlemen. I was mentioning to MP Rambali earlier today that I feel like all I've talked about for the last week is this judgment, but it's better that we talk about the judgment than we run and we hide from the population, which is apparently the PNM approach to it. And I think that that alone illustrates the difference between the UNC and the PNM. The PNM, Rowley has been, I think, on the golf course. He has been hiding. I think Al-Rawi is in some sort of witness protection program. He's missing in action. And Amo embarrassed himself, and I think the Law Association has dealt with him appropriately, but he has embarrassed himself by not just cherry picking and trying to count judges. I think that's a new Duckworth-Lewis system he employed or something like that to try to contrive some sort of a win for the government by counting judges from different stages of the litigation, but also went and stooped so low as to basically threaten the media and the public with contempt if they made unfavorable comments about his judgment to the about the government. Well, I think if he were to pursue that line of action, he would be suing every single member of the public, because I think everyone has seen for themselves coming out of this judgment what this government tried to do. Ladies and gentlemen, it is a slap in the face of the population. It is the height of disrespect, and it shows you that this is a lawless government that has gone rogue. That 1 week after this very important judgment being handed down, we are still waiting for people to, as MP Rambali said, miraculously break their silence. Why is there silence to begin with? Last week, Thursday, instead of Amo, as I say, embarrassing himself, looking quite, he looked very, what's the word, discombobulated. He looked very, I don't know how come, because you know, we got advance notice of the judgment. I think Senior Counsel Martin Daly made mention of this on a morning program, that the legal teams, although you are not allowed to disclose it, would get an advance copy of the judgment. So the government knew in advance, or ought to have known. I don't know if someone hid it from them or from Armour, but they ought to have known that this was the situation. And the fact that no one on Thursday had the respect for the rule of law, had enough respect for our apex court, and had respect for you, the citizens of this country, whose right to elect your local government representative they took away. They took that right away from you, and they could not even come to the population last week Thursday and beg for your forgiveness. And in an act of contrition, what they ought to have done is to call the election date. That was the only thing we wanted to hear on Thursday. That is what I expected to hear from a responsible government. But my hopes were obviously too high, because we have a very irresponsible rogue government that for the last week has allowed a situation to occur where you have persons perhaps in different corporations seeking guidance, not having guidance, and doing things which, as MP Rambali has already explained, would not be covered, in my respectful view, and that is my preliminary view, that nothing that happened after Thursday could be covered by this de facto officer doctrine. You see, in order to operate as a de facto officer and to be covered by that doctrine and to have your actions saved and to avoid an avalanche of litigation, you had to have been operating under the impression, the mental element here is what is important. You had to have been operating under the impression that you had the authority to do the things that you were doing. Once this decision was handed down on Thursday, how could you say that anyone was operating under the impression that they had the authority to do what they did? So anything done after Thursday, no matter what law you bring, no matter what doctrine you cite, in my respectful view, cannot be covered. They do, in fact, have to bring an act now to validate, but they cannot simply drag their feet on that matter and say, well, let everything continue and we will validate it down the road. Again, that is lawlessness. That is a total disrespect for our apex courts. It is a total disrespect for the rule of law in Trinidad and Tobago. And I will tell you this, ladies and gentlemen, I'm a bit hoarse because I spoke a lot in the parliament yesterday about the fact that this government is simply taking our democracy down a road towards total and complete, failure. We are falling apart. We are becoming a failed state under a failed government. And the first sign of that are the incursions upon our rights and the total disrespect for democratic principles that this government is obviously very comfortable with. For 1 week, they have been relaxing whilst we have a crisis in local government. And we have a situation where laws are simply flaunted. I just want to make one little small correction. The case was filed in November, but the term of office came to an end on the midnight on the 2nd of December. So as of the 3rd of December, 2022, no councillor and no alderman had an office. And that is what the Privy Council ruling means. Even if you were doing things from then to last week Thursday, you were operating under the impression that you had an office. Well, that you were operating under a misguided impression. You no longer have an office. So all this talk about people are independent and cross floor, I don't know what floor you're crossing. There is no floor. There's no floor to cross, and we really have to understand that the issue here is that you have been operating under the erroneous decision made by an incompetent government to no fault of your own. I blame none of our local government representatives, but I want to tell you today, you have no office. You have no office to go to. You have no office to stay away from. You have no office to resign from. Your term of office ended on the 3rd of December, 1 minute past midnight, on the 3rd of December, 2022. And the law is that 90 days from the 3rd of December, which would take you to about the 3rd of March, an election was supposed to be called. And during that period of time, the mayors and the chairmen of corporations remained in office, were supposed to remain in office, and run the administrative side of the corporation together with the CEOs and the health inspectors and the public health inspector, the other chief engineer and so on. All of those other offices are created. That is how our Municipal Corporations Act is crafted. That time has now gone and it is past. So what are they doing? They are all operating illegally. And the longer this government takes to rectify what has happened, to call the election date and to bring an act to validate the things that have been done, is the more exposure our corporations have to legal action. And as I join in saying with Dinesh, as I have said before, this is how I don't know if sometimes So it's hard to believe that a government could be so intellectually inept and incompetent. And sometimes I believe that it is deliberate on their part, that this is a make-work program for lawyers. Yes. They are creating litigation, you know. I stood up there and listened to Stuart Young lambast Ravi Balgobin Maraj. But at the end of the day, Ravi Balgobin Maraj and his slew of litigation against his government brought in as an act of patriotism to Trinidad and Tobago has filled the pockets of losing lawyers who the PNM appoint. So whilst they complain on the one hand, their friends and family and financiers and colleagues in the legal profession have become rich. They have not been able to beat Ravi in any matter or Ram Logan, but they are getting rich off of this. So I have to ask myself as well as Dinesh, what is happening here? Is it that they are waiting for litigation to come? Is it that the threat of litigation to call the election date by the leader of the opposition, again, standing strong and firm in defense of the rule of law as she has done time and time again? Is it that what they are seeing now is dollar signs? Because they are saying, okay, more litigation means more legal briefs, more work for the boys? Because I have to say that should ring and send off alarm bells to the population. They are coming to Parliament to discuss further legislation to implement property tax. You have so many other areas where the government is talking about revenue generation, and yet the legal fees that they are willing to pay to defend the indefensible in this country. It is alarming. That is your money, ladies and gentlemen. That is money that is not paving roads. That is money that is not patching potholes. That is money that is not going towards fixing CCTV cameras. It is going into the pockets of lawyers who are getting rich because of the incompetence or the willful acts of this PNM administration to simply disregard the rule of law. I also have a quote that I like, and I think all of us would know that there's something that would have inspired us to take up the professional route that we have taken up. And it is that let no man live uncurbed by law or curbed by tyranny. We have a cabinet under Keith Christopher Rowley that is living uncurbed by law. And we, the people of Trinidad and Tobago, the citizens, are curbed by their tyranny because we are being deprived of our rights. What the Privy Council said in this very important judgment is that the right to vote in is just as important as the right to vote out. And what the government did in this case is that they took that right away from you and essentially implemented and interpreted law in a retrospective manner. What that means is they went back to 2019 and said, listen, you're no longer voting for someone for 3 years and you will no longer have the right to vote them out 3 years from today. I'm changing that to 4 years' time. And the Privy Council ruled that that was wrong. They said that the wording of the legislation passed by the Parliament, and I will get to Senator Dialsing just now on that point because he seems to have misunderstood in a very critical way the ruling of the Privy Council. They said the wording of the amendment approved by the Parliament was prospective in nature and forward-speaking and will therefore apply to persons in the future. In November, the government decided that they will proclaim it and said, well, we interpret this to mean it goes back to the 2019 election and it will apply to sitting councils and aldermen. And that is the fundamental flaw and the concentric issue in this matter is just simply that government's flawed interpretation. It has nothing to do with the Parliament, the opposition, and if the independent bench want to make apologies on behalf of the cabinet and take blame, do that on your own. I don't bring me in that. Don't bring us in that. And I would also want to point out that the opposition didn't support this entire package of legislation in either house because we have other concerns about it, which we will get to perhaps as a whole other press conference. But we've spoken about that already. I want to say that I join with my colleague, MP Rambali, and say that unless an election date is announced today, we will accept nothing less than that. They cannot continue to operate under the impression that they could just disregard the law. An election date, and I think all of the media that MP Rambali has helpfully taken us through this morning, and the media are the voice of the people to an extent. They express what the people are saying, what the people are feeling in this country, what educated observers, political scientists, and so on, constitutional law experts are looking on and saying that an election date has to be announced. The PNM are clearly mortally in fear of the electorate. And that is what prompted them. They think that they think that we do not understand why it is they came up with this interpretation. I know, and they know that I know that everyone has read, or at least everyone who passed through law school, which we assume some of them have done, although we have our doubts at times. But everybody has read Benyon and statutory interpretation, and everybody knows that legislation is always forward speaking and that you cannot have retrospective application. What happened to them is that coming towards the time when they knew the election had to be called, we were the newspapers, social media, everything was filled with criticism and concern from citizens as we approach that 600 mark of murders. They were in a very bad place. And I think Professor Ghani today in one of his comments says, listen, they are not going to call an election until they think the climate is favorable to them. I don't want to misquote him, but that's basically what he says. That is wrong. You cannot simply kick the can of an election down the road until you feel you have won some sort of popularity contest with the electorate. They came in their budget and they moved certain portfolios out of local government, which I think, for whatever reason, I've heard stories I will not repeat, but I've heard a lot of concerns were raised and so on. They moved the secondary roads company out of rural government into the Ministry of Works, made a huge allocation. I think was 100 million, then another 100 million, and it's been growing. But they have not really made any significant impact in rectifying key local government issues. Faris just simply failed again. They had to remove him from the portfolio of Attorney General after his many blunders, not the least of which was Nelson Gate. And they put him in rural development thinking that, in the lead up to an election, things would get better. But things have gotten worse. Flooding is worse. In the dry season, we have flooding now. And they'll say, well, that's Mother Nature and they can't. But the fact of the matter is, local government is in a mess. It is in a complete mess. And local government elections is not just about local government issues. People vote on bigger issues because they are judging the government. And so they are running scared. They have been running scared from the electorate since December. And if today they stand in that parliament and say anything except when the election is going to be held, that is all of the validation that you need that they are living in mortal fear of the electorate and that they have absolutely no regard for the rule of law. Let me take you back now to what I mentioned before about what Senator Dialsingh had to say. And this goes to the very heart of this judgment. I do not want, because I noticed it got coverage in all three newspapers today, and I want to make something abundantly clear. Nowhere in this judgment of the Privy Council does it say that Parliament had any role to play in the implementation of a bad law. What the Privy Council has criticized and what they found to be unlawful is the cabinet, the government, Al-Rawi, and Amor interpretation of this amendment. So the fact that an amendment was passed by Parliament to increase the term of office from 3 years to 4 years wasn't found to be unlawful, It was found that it will apply to future elections and councillors elected at the election which is due and which became due after the expiration of the 90-day period, which is around the 3rd of March. Nothing is wrong. That provision will apply when we have an election. But it is Al-Rawi had a press conference. In fact, I will give you the war room stories now that I can, that the election is completed. Al-Rawi's press conference featured prominently as evidence in this case, because he is the one that made an announcement about the proclamation and said, well, this is the interpretation and this is how it is to be interpreted. And he's advised, they always advise. They advise you that they have been advised and they can now advise. That's how it goes. And all of that says that a lot of money has been spent on lawyers. And money for what? You were wrongly advised if you were advising yourself or if you got advised. You were wrongly advised about the interpretation of that. So Parliament could make the best laws in the world if you have, again, an inept, incompetent, and I would say in this case, deliberately incompetent government running from the electorate and looking to place an interpretation on laws that suits them, then no law will ever be implemented properly. And that is what we had in this case. So I would like to invite Senator Dialsingh to correct himself, to review this judgment, and if he wants to soften the blow against the cabinet and the Keith Rowley-led administration coming out from this judgment, which is clearly they have been getting blows for the last week. Well, do that on behalf of yourself and speak for yourself, but do not speak for the entire parliament, because we are also parliamentarians and we took no part in these shenanigans which led to this decision. In fact, from day one, Mrs. Prasad Bisesa came out and told them, you are wrong on that interpretation. They did not listen. Had they listened, they could have avoided this crisis which we have right now taking place in the country. The de facto officer doctrine that they claim they will use, there's a lot of law out there and there are a lot of case law, there's a lot of academic material out there, which again I would invite the Attorney General to have a review of, because it does not protect what is called intruders or usurpers. And what they have done by sitting down on their hands for the last week, anyone who has acted in the last week is a usurper, because you do not have that false impression operating in your mind that you have legal authority. You are very clear. Everybody should be very clear in their mind right now, all local government practitioners, that they do not have legal authority. So anything that they have done, you are an intruder into your office, you are a usurper, and those are the terms actually used in the law and in the academic material that deals with this notion, and you will not be protected. I repeat that, you will not be protected if you continue to act while the government remains silent and you continue to function in an office which you are not entitled to occupy. I saw many councillors taking the initiative to write. Well, I understand Kent House has shut down completely. Nobody, they're not even answering the phone. I think they unplugged the phone in modern terms. I don't know what is the modern term for unplugging the phone, but I think they unplug the phone, take it off the receiver, and they can get no response from the government. Again, total disrespect by the Minister of Local Government who created this mess, but total disrespect from him for our local government practitioners, for all local government practitioners, regardless of what party they belong to. They deserved you having drawn them into this mess where they could even face personal liability. Yes. They could even face personal liability depending on some of the decisions that have been made. The corporations could face lawsuits over contracts. You can see contracts, people suing to have contracts rescinded. They could challenge the award of contracts and so on, because those things were done by an invalid corporation. So in the absence of a government taking action to correct these things urgently, we are in a dire state of affairs, ladies and gentlemen. I want to touch briefly, though, as I said before, on some of the evidence in this matter, and this will tell you why it is they are now in a legal, ethical, and political quagmire, so to speak. They don't want to call an election because they are not ready. Things are in a bad state for them. Crime, I think, is the number one concern of the entire country. It weighs heavily on the mind of the electorate. We have a police service that has taken a strong stance against buckets, and the electorate is very upset right now with the state of affairs in this country. So they are not prepared to face an electorate. Crime being one matter, there being several other matters affecting them. They would like to extend the time of the existing corporations. But the time to do that, and some commentators have said that it was done in the past, the time for them to do that would have been before the expiration of the term of office. That was done under the Manning administration, who had also promised local government reform. It never really came. That's one thing you could guarantee with the PNM. They will take many, many years in office to do what our UNC government was able to bring in a very short space of time. We introduced proportional representation, and we were able to implement some reforms at the local government level in the short time we had in office. But for many, many years, they were promising local government reform, and they deferred elections on 3 occasions when the Patrick Manning administration was there. But before the end of the term of office, they came to the parliament and expressly brought legislation. And part of our case was that the model for extending the term of office for councillors and aldermen existed. And why did this government not do it? It is because they did not want to face the political consequences. They did not want to face the parliament and come and say, listen, we want to put off the election and extend the term by 1 year for councillors and aldermen, and to have the corporations continue to sit whilst we do X, Y, and Z, etc., because they know that we would have held them to account in the parliament with something like that. We would have questioned their motives. We would have highlighted the spectacular line of failures that they have trailing behind them, and that the population would have seen through that. So they decided to come up with this statutory interpretation argument, which has now flopped on its face in the Privy Council. Well, apart from that, they have a challenge now with allowing corporations to continue to run in the way that it would have run if, during that 3-month period, because the Minister of Local Government put an affidavit into evidence in this matter. And this affidavit is really, it's good fictional reading, I would say. In fact, it could win a prize for fictional work of the year, perhaps, because we asked the court to injunct the government and injunct the local government practitioners from continuing in office beyond the 2nd of December, from the 3rd of December, so that this matter could be given priority and could be heard and determined, and you will not have people being paid illegally and doing things that could then be illegal, which is what has happened. All our local government practitioners, UNC and PNM, have been paid for 6 months when they had no right to be in office. And they have done other things, other actions as well, as we have discussed. And we went to the court early o'clock as a responsible opposition and with the aid and alliance of Mr. Ravi Balgobin Maraj, and said an injunction should be granted. Faris Al-Rawi went on affidavit and said, we fondly referred during the course of the trial to this as the chicken licking affidavit, because he said, oh God, if you do that, the sky is going to fall down. Nobody garbage getting picked up. If it have flood, they cannot open the shelter. And we made the point that you could have the law catered for an interregnum between the end of the term and the calling of the election in 90 days. And within that period of time, the CEO and all of the other officers of the corporation could run the corporation. He said, no. I want to take you through all of the things that he has said, and more of it will be said, I think, later today. But he said, look, you can't do that because, they can't implement any projects. They will not be able to access their funding. He listed out here about, about 40, this is what, that's 36 things, that local government supposed to, and say none of that could happen. He talked about town and country planning. He said they can't make bylaws. He said they cannot grant license. Market people cannot get license. They can't open the market. They can't clean the market. They cannot impound animals. They cannot pick up vehicles. They cannot do anything. And so you cannot stop these councillors and aldermen from occupying office. So now, in the face of this, they are trying to work around this now. Because if they were to come and say, well, we're going to validate all the past acts done, and we're going to allow councillors and we are going to allow the corporation to run with the chairman in place and the CEO alone, which is catered for after the term of office of councillors expires, they will basically be saying that Al-Rawi was a liar. Because this is sworn affidavit evidence. So they can't do that. So that's one option that they cannot treat with, because they have a problem with Al-Rawi and his evidence. The other thing is that, as I said before, bringing an act to Parliament to extend the term before the end of the term of office means that you allow for parliamentary debates, and Parliament will agree that it can be done. The term of office having come to an end, the time for calling the election having come and gone, because they dragged their feet and did not agree to the urgency of this matter when we were in the High Court. And so we did not get to the Privy Council until very late in March. The time had gone. We had to wait for the Privy Council decision. They are now having to find a way to draft legislation to perform what we call a Lazarus miracle and resurrect the dead, because the council died. That council, constituted by councillors and aldermen, died on the 3rd of December. And I have heard the political views being expressed by people, very senior people at the university and otherwise, that is a really tricky type of situation. In fact, I am not even certain that could be done in law. The legal team is certainly looking at all these options. But you know what it boils down to? It boils down to knowing a few days in advance that this is what was going to happen. Knowing full well that they caused this chaos to ensue from their bad decision making and their erroneous interpretation meant to shield them from the electorate. A responsible government would have taken action already. They would have already sought advice, and they would have simply called the election to minimize all these problems. But they continue to drag their feet. They continue to operate as though they are above the law, and they continue to leave Trinidad and Tobago in a state of disarray, particularly in the field, in the area of local government. And so nobody knows what is going to happen right now. Ladies and gentlemen, I want to give you the assurance that the leader of the opposition, Mrs. Kamala Prasad Bissessar, senior counsel, and others, including Mr. Ram Logan, and other attorneys. We have no shortage of not just attorneys, because the PNM have a lot of attorneys too. We have no shortage of bright attorneys and hardworking attorneys in this party, led by one of the brightest and one of the most hardworking attorneys. And I have to say, because of my personal involvement in this case, I can say Mrs. Prasad Bissessar knowledge of the history of local government. I think people forget that she started off in local government as an older woman. In what was then St. Patrick's County Council, but her understanding of local government placed her in an excellent position to perform the type of legal analysis that was necessary in this claim, and it served us very well in our preparing our arguments at every stage, and more so in the Privy Council. And I want to say today that we are working under the leadership and guidance of the honorable political leader. We are looking at this issue, and whatever the government says today when they come to the parliament, whatever Dr. Rowley comes to the parliament to say, we are certainly going to look at it in the context of whether it is lawful. And I think we have shown beyond the shadow of a doubt that anything that this government does that steps outside or beyond their remits and is not in accordance with the rule of law, we are prepared to take them all the way to the Privy Council. We will use our voices in the parliament. We will encourage the population, and we will participate when the population decides that they need to raise their voice outside of the parliament. And we are prepared to go to the Privy Council if it is necessary to uphold the rule of law. The UNC stands in defense of the rule of law. We are, I think, the last remaining strong, solid, cohesive institution standing in defense of the rule of law in this country. And I would say, thank God for the UNC, thank God for Mrs. Kamala Prasad Bissessar, and thank God for the Privy Council. At this point in time, I think, I don't know if MP Rambali wants to add to anything that was said, or we could take some questions from the media.
I want to particularly thank Senator Lachmidial after that comprehensive, indulgence in the case and the consequences. Ladies and gentlemen, there isn't anything I can add to what Ms. Lachmidial has said. Do we have any questions from the media?
Yes, indeed. We know today the Prime Minister is expected to address Parliament on this issue. As you said, the opposition is demanding a call the date for the LG. But is it possible for him to call the date for the LG without first passing an amendment to attempt to correct this error that has been made?
Yes, it is possible, because local government elections will not, calling of the local government elections or announcement of the date does not result in any suspension of the parliament. So we can have the calling of the local government election date forthwith, which is what we are demanding. And alongside that, you can have whatever you wish to bring to the parliament, which we would expect the validation package of legislation, if I may call it that loosely, that it can be brought to the parliament so that we can protect the rule of law, we can protect our local government officials. We have to recall, Ms. Lachmidial, I'm sure this would have featured in your case, these persons who appear as councillors, aldermen, they are volunteering themselves to perform in that level of public office.
Public service, yeah.
And so that it is more public service for them. I can't understand for the life of me why the government will not. These people who get in the trenches, they are the first port of call when you have emergencies, when you have disasters. They're the ones who initiate the DMUs. They're the ones who out there, if there's a fire with someone's home, whatever it may be, that you will not seek to protect these people.
Yeah. I just want to add to that though. Under the Municipal Corporations Act, there are a series of steps that have to be taken before the actual date of the election. So, and we calculated it actually as part of this case, it's about 35 days that you need. So the longer that they drag their foot, even if they call the date today, it will still take 35 days for us to have an election. And that in itself is enough reason for them to act with haste. As I said, they are a week late. the election day should have been called last week, and things should have been started to happen and put in place. Nomination days should be announced and so on, because these things have to happen before the actual date of the election. So, they really need to get cracking on that.
On that point, let me just add one point, which is before I lose sight of it. Ms. Lakshmi Dayal, carefully and given her participation as counsel, junior counsel in this case, of Balgobin Miraj and the AG, the cabinet. What happens from time to time, not in all cases, but in some cases, the Privy Council will give you an advance judgment, which is what she would have referred to. When you get that advance copy, it is, as they say, it is issued embargo, right? Yeah. There's an embargo which the Privy Council puts on it, meaning that if you disclose the contents of that draft, that advance draft of the ruling, you can be held in contempt of court. So what they do, it is really limited for the eyes of the counsel, and it is limited for the eyes or advice of the client. The significance of that is that, as Ms. Lakshmi Dayal said earlier, they would have known, and in this particular case, not us on this side, the opposition would not have known. We were not the client, right? We would not the client. Mr. Balgobin Miraj was the client, so he and his counsel would have known. But on the side of the government, they are all clients, because this case was brought against the entire cabinet. So their counsel would have gotten copies of the advance copy, and they would have had to discuss and provide a copy as the case may be, but certainly advise what the advance ruling is to all members of the cabinet, because they were all named in this case. So that is something I wanted to point out in case we lost sight of it, but Ms. Lakshmi Dayal touched on it, and I want to make that abundantly clear. So it is not as though they are like fish out of water only when the ruling came. If they are fish out of water when the ruling in fact came, as I said, is some kind of paralysis analysis. It is just being hell-bent on disrespecting the rule of law on their part.
Yeah. As I said, it was quite shocking to see how confused the Attorney General looked. It was quite shocking to see that the Prime Minister didn't come with a plan, that he wasn't prepared, because they ought to have had advance notice of this and advance sight of the judgment and known what was coming. The judgment is released so that counsel would have sight of it for proofreading and so on. But you know, and your client knows what is happening with the judgment. So we can't understand how it is that they could feel comfortable rocking back and relaxing and not doing anything to prepare and to take charge of a disastrous situation of their own making from last week Thursday to now.
And sometimes with these, if it, as in this particular case, where the ruling is going to, it's not a private litigation, right? A civil suit between two individuals, that the ruling will affect both of them, right? In this particular case, the ruling is going to affect an entire society. So that is why, if when you get this advance ruling, if you, not that you can re-argue any point, but if you need clarity on something as to how it will impact, the ruling will impact upon the wider society, you can ask those questions of the law lords. So this was the kind of accommodation given by the Privy Council, notwithstanding we have people professing to be, all of a sudden experts in jurisprudence and how they...
How much public law litigation have they done? Have you ever seen them in a public law case?
So, and that is the point, where you have people criticizing the Privy Council. Look at what the Privy Council did. Gave the judgment, as they have done, as I say, in certain matters. This was one of them, where it is of far-reaching consequences to the wider society. It is of national importance. The entire government would have been privy to this, so that they could have asked questions, they could have sought clarification on any part of the judgment. They could not re-argue. I make that point. It is not expected that you re-argue any point. You can seek clarification. The Privy Council will, of course, use its discretion to entertain or not entertain, giving the other side natural justice principles to be heard as well. And that is what they had. All members of cabinet are named in this litigation. They would have been privy to this.
Ought to have been privy.
Or ought to have been. Well, if they were not privy, maybe
that is the internal problems. But
that is a matter for them.
Yes.
If the Prime Minister comes to Parliament today and does not call a date for the LG, what is the next step for the opposition?
Well, I think Mr. Sasa has made it very clear that we are willing and able and committed to exploring our legal options. The work has already started on research in terms of what we can do, and a pre-action protocol letter is being looked at and being considered at this point in time. It may very well be that we may have to initiate contempt proceedings against the government, because they are really in contempt of the judgment. They are also in breach of the Municipal Corporations Act, because based on the interpretation, and I come back to the interpretation point in this because that is what is important. Based on the interpretation of the Privy Council, all councils came to an end on the 3rd of December, and an election was due 90 days from there. The failure to call an election between the 3rd of March and the 18th of May, you were operating under the misapprehension that you didn't have to, but as of the 18th of May, you have absolutely no reason for being in breach of the Municipal Corporations Act and calling an election. So it may very well be that we may have to file a claim against the government, asking the court to declare that they are acting ultra vires the Municipal Corporations Act, and ask the court to issue a mandatory order compelling them to call an election date. That is one consideration that we have. We are, of course, as I said, it's a team of a lot of teamwork spearheaded by the honorable leader of the opposition, and we have to consider the many options. We would also like to hear what they have to say and their reasons, because sometimes it is in the articulation of their reasons that they put their foot so deep down their throats that we are able to succeed in some of this litigation. So I would be very interested, and the legal team will be we'll be watching to hear what they have to say today, and the justification and explanation and the logic or illogical path that they may take when they speak in the Parliament this afternoon.
Admirably, you mentioned that we have fallen down the global rule of law index. Are there any specific reasons as to why we have slipped 4 places now?
Well, the way the rule of law index works is that they measure by virtue of feedback that they actually receive from citizens of Trinidad and Tobago. So you will see that in the report itself, they would index all of the persons who they spoke to in the jurisdiction, and you would see that lawyers, people from civil society, some certain government departments, as well as citizens themselves, ordinary citizens. And what happens is that they would take a measure. So what has happened is that certain countries, and Trinidad and Tobago was one of them, that we would have dropped in the ranking, as I said, in the 2021 report. And then 2022, just 1 year later, we dropped a further 4 spots to 67. And this is something that I haven't gotten down into the nitty-gritty of it. But what it means is that when you look at the constraints on government powers, you would see that we dropped in that overall factor, meaning that the government is really operating like a road. Yes, a lawless. When you look at absence of corruption, that is something that we don't feature properly on. I mean, we are actually scoring badly. When you talk about open government, this is something that we are also scoring badly. Fundamental rights, the government's respect for fundamental rights, they are not doing that. Order and security, I need not get into that. We need not get into that. We all see it every day in the papers, order and security. In fact, when you look at the global rank for order and security, we actually are 103 out of 140. So that is to show you how badly off we are. Regulatory enforcement, 70 out of 140. That's the global rank. Civil justice, 54 out of 140. That is not too bad. Criminal justice, 121 out of 140. So when you look at these rankings and you look at the factors, the respective headings that they score and they utilize to score us under, you can see why it is we have dropped in the rankings. And it's not limited to one. It is across all of these factors. So we are actually scored in terms of Latin America and the Caribbean, and we also scored globally. And as I said, it seems as though Dr. Keith Rowley is intent on carrying us down to 140 alongside Venezuela.
It was perhaps a bit coincidental that on the day that this judgment was handed down, there was also an article carried in the Express that spoke about our low scores in something called a rule of law survey conducted by another organization based in Washington. I made reference to it in the Senate yesterday because it was so timely. And in that, that's a survey carried out by an organization called World Justice Project. And in that case, we scored very low. Almost 80% of representatives ruled that the top government officials attack or attempt to discredit attempt to discredit some of the media, civil society, and so on. So it is really they spoke a little bit to some of the rankings that they use, and in most cases there were you would have like 3/4 of the respondents basically saying that they did not have confidence in the government, and this came out on the same day that this judgment was delivered. So if it came out, if the judgment had been delivered before, we might have scored even lower, because what you have now is a government really interfering with rights to vote. And that is another thing about this specific interpretation case. One of the factors, and again, I would ask Senator Diaz Singh to go back and read the judgment before he tries to absorb blame on behalf of the cabinet and to share it with us, because we take no part in that. One of the factors that the Privy Council highlighted here is that when you are dealing with voting rights, it is so much more important that you interpret laws properly and that you have clear and specific language. So it was bad drafting to begin with, not to say when the thing would take effect. That was bad drafting brought by the government. And then their interpretation was also held to be erroneous. So I think they were doubly wrong in this case. And, it is the government's responsibility, when especially dealing with the right to vote and to elect representatives, to be more cautious. And all of these things affect the perception that people have on the rule of law.
Those are all the questions we have.
Okay.
If I may just quickly sum up, because this is a very important matter. Usually when we do our presses, you would hear Ms. Jayanti Lachvidiyal speak on other things. That is, of course, affecting the nation, and I like to speak on other things too. But this is very important. Let me say that when we look at the judgment, I want to just utilize the wording of the judgment. And what it says at paragraph 31, and Ms. Lachvidiyal has touched on this, the right to vote out representatives is as important as the right to vote in representatives. At the end of the period for which they were elected, the electorate has the right to decide, and this is something we heard today, whether they wish the incumbent representatives to remain in office, assuming they stand for re-election. So that is how important this matter is to Trinidad and Tobago. They go on at paragraph 34. It is inimical to a representative democracy that the representatives are chosen by anyone other than the electorate. So what the government is in effect doing, and Ms. Lachvidiyal and her team would have marshaled this before the Privy Council, it is not for the parliament, still less the government, to choose the representatives. The longer they take to remedy the situation, the longer they take to announce the local government election date, they are in effect putting themselves in the position of choosing the representatives, choosing your representatives. It's supposed to be for you to vote, and by popular vote, the person is chosen. They are doing opposite. So that is what the Privy Council has said. And Ms. Lachvidiyal, you spoke about lawyers. The difference between the lawyers that are affiliated and traditionally support the PNM, nothing is wrong in that by itself. But I could tell you that the difference between those and those on our side, the United National Congress, we seek the interest of the citizenry. We promote the rule of law. We give advice, and we take advice from the political leader as well in terms of adherence to the rule of law. So, to sum up very quickly, we call on the government. We are not prepared to accept anything other than Keith Christopher Rowley as Prime Minister announcing in the government today this miraculous breaking of silence on his part. He must announce the date for the local government elections forthwith. That is the only thing we want to hear from him. And otherwise, to give some kind of inclination as to an announcement, a proper reassurance, an announcement that the government will bring the validatory legislation to validate the actions of local government elections for the relevant period of time. So we call on the government for that to be done. I will say that, Ms. Lachvidiyal, I trust that we share this platform together in future, and so we can get more quotes. But one quote I will end with is that a body of men holding themselves accountable to nobody ought not to be trusted by anybody. That is, of course, Thomas Paine, and that is the government we are dealing with. A body of men holding themselves accountable to nobody ought not to be trusted by anybody. So I leave that there, ladies and gentlemen, on behalf of the Honorable Leader of the Opposition, Mrs. Kamala Prasad Bisesa, Senior Counsel, on behalf of Ms. Jayanti Lachvidiyal, Honorable Senator, myself, Dinesh Rambali, and all our parliamentarian colleagues, I wish to thank you all for joining us, and we will keep you all up to date as we insist on ensuring that we carry out our public duties in holding the government accountable. And so let us see. We can only hold with bated breath that whether the Prime Minister will act appropriately. So thank you all. Thank you, members of the media.
Thank you, everyone. Have a good day.